What's up, everybody? You asked for a breakdown of Sarah Boone's most recent motions. There are three of them. The court has already ruled on some of these issues. He has reserved ruling on others. We'll talk about what she's asking for. We'll listen to how she makes these arguments. That's the most interesting part to me. And then what we think the judge is actually going to do at the end of the day with each of these three motions from Sarah Boone. Hit that like button if you guys have not already. Let's get into it. So Sarah Boone has already made multiple motions in her early representation of herself, and some of them she's won. The court has granted those motions. Some of them she's lost. The court has denied those motions. And many of them, the court has just either reserved ruling or denied without prejudice, meaning you can refile these with more specificity in the future when you know more of the answers, but you're doing things timely. You're protecting the record. You're not losing out on the chance to do things. You're not forfeiting your own rights in the situation. So let's see how these go. This first one is a motion for defendant's immediate address correction. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from the court to change, update, correct the defendant's delivery mailing address immediately. The defendant is unclear how the court had the correct address prior to the forfeiture of her counsel by the court and forced to be pro se, and now does not. This incorrect address was not provided to the court by the defendant, nor requested ever to be changed. So a little bit of side eye here from Sarah Boone, like, what happened? Why don't you have the right address now? Why all of a sudden now is it more difficult, and why does it take longer to get things to me with this incorrect address? All correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real-time response, proper notice, and preparation on any requirement contained therein. She's 100% correct here. The defendant is requesting the court please forward the correct address to all parties affiliated with her criminal case, including all portals, correspondence, tags, and all lists the defendant may be attached to by the court. Please also provide all necessary documents for official record of address change to be filed accordingly by and in the court. By this motion, the defendant is expecting no further hindrances, difficulties, deterrence in the court's fair and proper correspondence to be delivered to the defendant, and the following address is here, her correct address. Please be advised also the defendant mailed by USPS this information by formal letter to the court August 1st, 2024, to emphasize the importance of this immediate correction to be made on the court's behalf and from the court's error. Wherefore, Sarah Boone, et cetera, and then her oath, certificate of service, et cetera. She's right. The judge said she's right. She wins this motion. Address has been corrected. Court agreed it was a mistake. Obviously, the court is going to say there's nothing nefarious going on. Obviously, we believe the court. But if I'm the judge, and just as a member of the public, I don't want to give Sarah Boone any excuses. We got to make sure we're doing this stuff right. We don't want her to be able to say, oh, hey, here's another delay caused by you, because that's correct. And we don't want that to happen. The more that happens, the more opportunity for appellate issues, the more opportunity that we're stepping on her rights, which nobody should want to do in Florida or otherwise. This judge does not want to step on her rights. So let's make sure we have the right addresses. Let's make sure there's not undue delay. Let's make sure things are done right. So that's a win for Sarah Boone. Next, the motion for the defendant to lawfully receive, review, utilize the original hard copy discovery submitted to the court by former attorney on June 28th for preparation of her trial. Comes now, Sarah Boone requests from this court that she gets the hard copies. Lawful support and valid reasons for this request made by the defendant include discovery, deposition, exploration, or examination, finding something out by search, observation, smart communication tablet dictionary, the process through which attorneys require or acquire evidence in a case and encompasses practically everything an attorney may or must do under the rules of criminal procedure to acquire evidence before trial, can be categorized such as documentary, testimonial, and physical, citing the law dictionary. Filed and posted on the clerk of court's website by the judge on July 9th. The evidence control sheet states A, box of discovery, B, box of discovery. The court will reach out to the jail to inquire how to deliver to the defendant and will provide written order to release both boxes. So to be clear, the reason the judge wasn't giving her the hard documents at first is because it's easier for her, it's better for her, it's more manageable for her, and she requested a computer in the past. She's also requested to see the documents in the past, but the judge felt like it would make more sense to give her the computer with all the documents on them. She's now asking for the documents in addition to the computer. And we know the judge has ruled that her investigator take the boxes of discovery out with him. And if between the investigator and the court and the jail, they can figure out a good way to store and give these to her when she wants to use them, even if it's outside the hours of her computer use, she can continue preparing her trial. It's the best of every world. And hopefully we can figure that out. And the judge is open to that at this point, even though he hasn't technically granted this because he doesn't know if it's possible based on the jail. She says the jail people at the jail tell her it is possible, and they do it for other people. These two boxes, A and B, are the defendant's original discovery. She has not seen in full to present date, and it is her right to receive by law to fairly proceed in her defense. Then she states, she kind of rewrites some of the discovery rule here, which we don't need to read through. The government is obligated under Brady to disclose information in its sole possession that is material to the issue of guilt or innocence. Any and all documents requested made intentionally unavailable to the defendant through discovery. Again, she's citing rules that don't necessarily apply here because the judge is not purposely hiding or keeping discovery from her. He gave it all to her on a drive that she can use on the computer that he provided, that the taxpayers of Florida are all paying for, but she wants it in this form too. Which again, I don't think is an overly bad ask or a reach or something that makes her controlling or hard to deal with. It's fair. I get it, especially if you're limited on the hours you can use your computer. Some people, even in my office today, like handwriting on things more than digital. I like everything digital personally. I can store it, document it, write on it, notate on it, save it for later, share it between different computers and my phone all at the same time, easy access wherever I am. You know, if I'm out of town, if I'm at home, if I'm at the office, I like it that way, but there are still some people that like paper. I see that as the ability to lose it, for it to be at the office if I'm here or North Carolina or somewhere else. Just can't get it, need somebody to scan it and send it to me then, and then it's digital anyways. But some people like the hard copy. I know a lot of people in the comments are going to tell me I like the hard copy, and that's totally reasonable. If one form of the defendant's discovery is unavailable, the other should be available without interruption for unrestricted full access to equal at all times to be able to lawfully prepare for a trial. Both are available to be provided by the court. So I agree with her, right? I think that's a plus. It's not a must, and I don't think if the judge eventually denies this or if the jail can't make it happen, I don't think any of her rights are being infringed on. But I think if we can do it, we should. Both are available to be provided by the court. Due to the court's error at not communicating with the defendant, foremost to avoid present circumstances, just the big words are just annoying, and the jail prior to the implementation of the order on June 28th and after the defendant's July 8th letter questioning the location of her promised hard copy discovery to boxes A and B as a direct result of her extended waiting period for delivery by the court to expeditiously review, research, organize all contents, and attempt to prepare all pretrial motions as ordered by July 22nd, 2024. The defendant is now forced in this abrupt manner to only receive and be restricted by the court USB copies of her discovery. It is an obstruction of justice to withhold the defendant's original hard copy discovery that has been compiled for ongoing 5 years to properly, fairly, physically construct her rightful defense and all available times necessary to her and on the sole independent decision of the court as the defendant, one, did not ask for or suggest this USB only option. She did ask for a computer, and the only way you can see the computer pages on the computer is with a drive. Was included in any decision-making, collaboration, or equal agreement for USB-only format to be received. You can start to imagine how her lawyers felt about her definition of collaboration, working together and checking beforehand. which is how she treats the judge, she's also got to realize we want to give her all these rights. We want to help her out. We want to do all this, but she is in jail. There's a reason she's in jail because of her actions, the evidence against her at this point. It's too great for them to give her a reasonable bond that she can actually cover. If there was no evidence against her, she wouldn't be sitting in jail. If there wasn't at least probable cause and a reasonable belief that she had committed a crime, even though she's presumed innocent, she wouldn't be sitting in jail. And when you're sitting in jail, you do not have equal rights to anyone, let alone a lawyer. So just be careful how far you push this line. Be careful how disrespectful you are in some of your language, because certain judges might not take kindly to that. She was never advised by the court prior to the implementation of receiving the USB copies, in quotes. The defendant was excluded and avoided in this incredibly restrictive decision. Time, consideration, and inclusion could and should have been made on the court's behalf to frequently avoid present disadvantaged circumstances, and the defendant would not be deprived of her due process and equal opportunity to correctly, fairly represent herself and succeed futuristically. Wherefore, Sarah Boone, okay, that's her wherefore clause, oath, and certificate of service. So the judge is working with Sarah Boone on this. He already reviewed this in court when we watched the motion and basically said, investigator, take the hard copies, work with the jail, see if there is a way we can make this happen. So one win, one wait for Sarah Boone so far. Let's now get to the last and most interesting one to me that the judge mentioned multiple times and said he needed to do some more research again before answering. But it is her motion for reasonable freedom in movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Comes now Sarah Boone and she asks for that. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of the defendant's hands, and as whole to freely, properly, successfully accomplish any task needed for. I agree with her. She should absolutely be unhandcuffed. Now, unshackled from her feet, I'm not sure they need to do that. I don't know why she would need to walk around the courtroom at any of these hearings. Now, during her trial, that's a different question. That's an interesting question as well. And if she ever does anything to violate it even a little bit, they'll reshackle her up. But the opportunity to walk around the courtroom during opening. Now, I've also seen judges do this, where they do the opposite. They leave her shackled. They obviously uncuff her hands and let her wear street clothes. But they tell the state, you also must sit or stand at counsel table. So it's even. So the jury never notices the difference. Sarah Boone can sit there and ask questions and object and do her opening statement sitting down or standing at counsel table. The state, same thing. They can't freely move about the courtroom either. We're going to level the playing field. State, you ask your questions, you make your objections, you do your opening, you do your closing, all sitting or standing at counsel table. That's an option for the judge at trial. But either way, I absolutely agree with her. Uncuff her hands, let her write, let her turn pages, let her use her laptop. She's representing herself in an impossible situation here. We've got to give her these opportunities, my opinion. And there's nothing in the law that prohibits that. And I don't think personally she meets the requirement of some dangerous defendant that is going to create harm or danger for anybody else in the courtroom, especially if her feet remain shackled and she remains further away from anybody. And there's a bailiff between her and the judge and between her and the state or any witnesses or victims that come for any of these hearings. Prior to entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographers, general public witnesses of the court, as well as vigilant armed deputies also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled and unhandcuffed. I gotta be honest, it's a well-written, proper, and correct argument. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, not by her, by the court. She's going to refuse to ever admit or take responsibility that she lost her right to counsel because of how she treated people, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. So what I'll also say is the court gives her these little things and grants these little motions. This is all helpful when, if and when I should say, the appeal comes. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested respectfully, seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. And again, I agree with her, but this is also why, use appropriate and respectful language. Don't accuse the judge of committing crimes and covering things up and obstructing justice, okay? That doesn't help. He's not hiding your documents from you by giving you a digital copy of them. He might not be doing it the way you want. He may have misunderstood the way you asked, but come on. And the language and how you act in those motions will help her in these motions, or anybody representing themselves, right? The proverbial you, or if Sarah Boone is watching this. So I don't think this is too big of an ask, but I also did not see or hear a single reason why her feet need to be unshackled in this motion. I personally would not unshackle her feet because that pretty much eliminates the flight risk and seriously diminishes the risk of danger, especially if we have vigilant bailiffs, like she said, vigilant and armed bailiffs there. Wherefore, pro se indigent defendant Sarah Boone requests this court to be unshackled, unhandcuffed, and allowed to be reasonable free around the courtroom. There is her oath and her certificate of service. So 3 more motions. Is that 6? I can't remember. 6 or 8 motions that she has filed already in less than a month of representing herself. I expect this to continue. I expect this to go fast and furious. I don't expect her to stop anytime soon. I think that she is going to ask for everything she thinks she's entitled to, and I hope she does. But also notice in every motion she files, she talks about how her rights are being infringed upon, how she's not getting a fair shake, she doesn't have her discovery, all of these delays, she's going to need a continuance, she doesn't want to represent herself, the judge is forcing her to represent herself, and all of those issues are going to continue. And in reality, she's protecting the record for the appeal that is going to come on this exact issue. Forced waiver, constructive waiver of her right to counsel, and not giving her a continuance when throwing her feet in the fire here. Telling her she's got to prepare for less time than he's told any lawyer that's representing her that they have to prepare. Every one of them got a continuance when they asked for it. Will she officially ask for a continuance? That's something I haven't seen yet either. If she's going to do it, she should do it soon, before September 1st, for sure. And put all these reasons in. I'm representing myself. I don't know what I'm doing. There were delays in getting me my USB discovery. Even more delays in getting me my documents, my hard copy discovery. You had the wrong address. More days that are going by that I don't have everything I need. And it takes forever for anything I want to write to you, whether it's a motion or a letter or some kind of correspondence, to get to you. I need more time. I think we'll see that. And if the judge denies it, at least she has protected the record by asking for it and not just assuming it's there, assuming the judge knows she wants it. All right. That's all we got. Let me know your questions in the comment section. Please make sure you guys hit that like button on the way out. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.